Hello everyone and welcome to my YouTube channel. My name is Eddy Meiri. I'm an attorney admitted to practice law in Israel and New York. I'm married and have 3 children and my law office is in Israel. Due to the fact that I am familiar with both legal systems, the Israeli and American, I provide legal service to many U.S. clients with various legal needs and interests in Israel, and in particular I provide my services to legatees or heirs of deceased persons who had left assets in Israel. Today I want to talk to you about probate proceedings in Israel, something that many U.S. citizens have to cope with at some point because one of their relatives, usually parents, have assets in Israel which my clients are due to inherit. We obviously won't be able to cover the entire matter in one or even a few video sessions, but I hope to give you at least the general outlines of the proceeding. For this first tutorial, here are a few basic facts to know about probate proceedings in Israel for foreigners. First, basic terms. Some people die leaving a last will and testament, or in the legal jargon, they passed away testate. In their case, the final outcome sought is a probate order. That's an order stating that the will is valid and should be followed and executed de facto. Some people die leaving no will, or leaving a defective and therefore invalid will, highly unrecommended of course. The term applicable to them is intestate, as in died intestate. In their case, the final outcome sought is an administration order, or alternatively in Israel, an inheritance order or a succession order. All probate or administration orders are territorial, or to use legal jargon, jurisdictional. That means they apply to the assets located in the relevant jurisdiction. In most U.S. states, if you have an original probate or administration order in one jurisdiction, a state, you can have it recognized in other states under the full faith and credit clause. Alternatively, if you have an order from a foreign jurisdiction, in most U.S. states, you'll only need an ancillary proceeding, which is shorter and simpler. In contrast, Israel has no ancillary probate or administration proceedings. For these reasons, if you have a probate or administration order from New York's Surrogates Court, for instance, or any other jurisdiction of the U.S., Canada, or some other jurisdiction, they won't help you with respect to any assets the deceased left in Israel, and you'll have to initiate a new probate or administration proceeding in Israel as well. In the case of foreign deceased persons, the Israeli Family Court held jurisdiction to hear the motion until July 2023. Now it is under the jurisdiction of the Inheritance Registrar. So we covered the 2 basic scenarios. We know we'll need a new proceeding regardless of any existing probate or administration order in another jurisdiction, and we know whom to address, but who is considered a foreigner for the purposes of probate proceedings in Israel? Well, unlike what many people think, it has nothing to do with the deceased citizenship. It also has nothing to do with the legatees or heirs' citizenship or domicile. It has to do with the deceased's domicile right before the demise. That means that if the deceased used to reside in New York, he is deemed a foreign deceased for our purposes. The most important consequence is that the law of the deceased's domicile is the law applicable to his estate, not the Israeli law, except for cases of renvoi, a term which we'll address on our next tutorial. Thank you for watching. I hope you've benefited from this video, and I invite you to join me on my next one. For any questions and comments, please call me at 212-461-088 or by email at eddy@meirilaw.co.il.